Good morning, everybody. This is Omar Serrano with the Tilted Lawyer Podcast, and I'm here for a very special episode. I had no intention of covering this case really ever again. I was always skeptical that I was ever going to do an interview with David Gingras, but he called me by name. I mean, not really. He just mentioned my name in a Twitter post as he was teasing the long-awaited sit-down interview with Laura Owens, and people were asking me about it. I haven't been contacted by Gingras whatsoever since the last time we talked on the phone. I've kind of just left it alone. Have been waiting for his appeal to drop. He sort of teased that yesterday. I wasn't aware, but he dropped a video late or early yesterday to talk about, I guess, some of the key tenements of his appeal. I have thoughts on that, but what really got my attention is my good friend Lauren Knighty summoned me from the Batcave late last night. It was like 11 o'clock or something. I was fighting off whatever my family was trying to give me, successfully, by the way. And she was afraid of getting sued by David Gingras. And he was threatening her with a $150,000 lawsuit because she made a YouTube video commenting on his YouTube video, and she was freaked out about it. And I went on her show late last night and tried to calm her nerves a little bit. I'm going to share with you guys a little bit of why any argument that you can be sued because you use David Gingras' content is kind of nonsense. And I'll break down the X, Y, and Z of why that is. I'm also going to talk about a little of the appeal that he wants to bring and why I don't think it's likely to succeed. I'll share my thoughts with you on that. That's going to be a little bit more nerdy of a conversation, but we're going to have it anyway. Look, he's been trolling the JFC community. I don't know to what extent he considers me to be a JFC representative because I haven't really been making content around this case other than stuff that's been directly affecting or involving myself. But hey, here we are. I got a lot to talk about. There's been a lot of threats made to a lot of people who I consider close friends of mine, and I want to set the record straight as to some of that. So it's going to be a wild show. I know why you guys are all here. We got a lot to talk about, so let's get started.
Whatever you might be going through and wherever you might be, this is Omar Serrano with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
Okay, so I got to get this off my chest. Lauren Knighty is a YouTuber. She has about 5,000 followers. She's been around, I don't know, since about like April or May. I don't know when she started her channel. But she put in a lot of work into getting the trial of Laura Owens televised. She's made a number of videos on the Laura Owens case. Hey, Angel from Australia, thank you so much for gifting 10 Tilted Lawyer memberships to unsuspecting members of the audience. I appreciate you greatly. Laura Knighty is, she's a friend of mine. I consider her a friend. She wants to date my dad. She keeps on asking for his number. I keep on trying to tell her my dad does not discriminate. If you say the word, he'll be there. I say that jokingly, obviously. But she's a good friend of mine. And so she calls me late last night and says that she's being threatened by David Gingras, who I've had personal conversations with over the phone. We've had contentious interactions, sort of. I did a whole video series about what I thought about the way he's handled the Laura Owens case, questioning some of his methods about the public nature of trying to litigate the case on Twitter, and going after specific people and what he has defined as the JFC community. I had a really good, hour-long conversation with him about all of these things. And what he had expressed to me was, look, And he came off exactly how you see him in the videos. I know some of you don't agree, but if you were to meet him in person and you knew nothing about this case, you would find him a charming guy, relatable on some levels, a good storyteller. He has measures of charisma, unbeknownst to some, but recognizable to many. And we had a good conversation. One of the things he said to me was, I understand that I come off a certain way. I can't help it, is what he said. I can't help it. When it's happening, I know that it's happening and I can't stop it, which is to say that it's a personality flaw that he goes after and attacks people. He's also been practicing law for like 22 years, I think. 22 years, give or take. And when you practice law for this long, it does something to your soul. To spend a career of yours in this adversarial, contentious environment where you're constantly bickering back and forth with opposing counsel and with judges, and you're constantly put on display to be judged by both your arguments and your performance and everything about you. Everything about you when you are a lawyer is on full display. The way that you talk, the cadence of your voice, the sound of your voice, the sources that you cite, the logical points that you make. Everybody is out to get you. Everybody's down there to tear down your arguments and make it seem as though you were incompetent. It's just how it is. And it starts pretty early from law school. I think the first day of law school, I have a special guest with me in the studio. Her mic is muted because I didn't want her to feel like she had to comment on this case. Priyanka, attorney Priyanka. She's a family law attorney here in the Inland Empire. Look, one of the things that happens when you're in law school is they tear you down and they tear you down and they tear you down and they try to break you. They try to get you to quit. They try to embarrass you. Day one of law school. Serrato, what is the definition of a contract? I don't know. A contract is a promise or a set of promises so made that one person offers a promise for consideration to another person, so made that the other party understands that their assent to such offer will complete a promise. No, that's not what it is. Well, shit. And then they pick on somebody else, and then you stand up in front of everybody, in front of the entire class, and they go about this business of setting you up and tearing you down and breaking you down, and that's how you start. Now, 3 years of law school, studying for the bar, you pass the bar, you're in. Now you got to practice law, and you're practicing law, and it's like this crazy thing. Holy shit, I'm a lawyer now. Now I have to know what I'm talking about. You have to. And the problem is when you're like a year or two in, most of the time you don't know what you're talking about. You're just kind of winging it. You're going off of what you think the law says. But what the law says and how it's practiced are two different things. And until you're a certain amount of time in practice, oftentimes what you think it says and what it's actually saying, those two don't marry until you hit a certain level. So Gingras has spent, and thank you, Willie Billy with the 5. Thank you so much, sir. You spend your entire career trying to belong. And then you have to make a choice. You're either going to use your powers for good or you're going to use them for bad. And I don't know anything about Gingras. I know somewhat about what he said about his legal career. I know him from my limited personal interactions with him. I know him from trying to threaten Dave Neal and his family and my friend Lauren Knighty. I consider Dave Neal a friend, Megan Fox, and all of these people have come together as a direct result of this case. I know him to be a troll. I know him to say things that he has no intention of doing because he knows that it's going to get a psychological reaction to unsuspecting individuals. And that happened to Lauren Knighty last night. She was in a lot of distress because she doesn't know, man. The guy's over here talking about he's going to sue for $150,000. Lauren Knighty is like 32 years old, I think. Apologize if I get that wrong, Lauren. 29, 30, 32. She's a youngster. She's just getting started. She's not a lawyer. And so she's being threatened by this guy who claims to be a defamation internet attorney, saying that because you've used my video and you're in the process of using it right now, I am going to sue you for defamation. Look, I think Legal Vices touched on it in his Twitter post last night when he was kind of scolding Gingras about taking that approach. Like, what are you doing? What are you doing? You know you're not going to do that. You know you're not going to subject yourself to a false copyright strike against a small-ish YouTuber for the sake of what? What, you're trolling her? You're trying to get one over? What are you trying to do? You trying to scare her? You trying to bully her? What are we doing? And then he goes on this discussion. I don't know if I could find that tweet. It was really good. If I type in legal vices X, is anything going to happen, Dominic?
No, I think it should be good.
Let me see if I could find his tweet, because what he said in the course of that I thought was instructive. I don't think. Well, you know what? If anybody has a link to the Legal Vices tweet from yesterday, if you could drop it in the comments, I would greatly appreciate that, because I wanted to share it with some of you that may or may not have heard it. Look, here is the law as it pertains to fair use in these YouTube videos. So the situation was this. Lauren Knighty makes a video directly challenging some of the views that David Gingras shared on his video. And in his video, he was largely focused on his upcoming appeal. He's written an appellate brief. I don't know if he's filed it yet, but he has it ready. It's like 75 pages long, something like that. He started summarizing some of his legal arguments, and I've spoken with him about his legal arguments. I disagree with him on all of them, and I'll explain why later, but this is more important. So Lauren admits, I'm not a lawyer, and she starts making her own points about why she disagrees with certain things that David is saying in his video. In the course of her recording that video,
Got the link.
oh, thank you, sir. Was that what that beep was for? Thank you, Bruce. Well, how do I copy it? So I gotta input it manually. All right, I'm gonna try that. In the course of Lauren Knighty making her video, she gets a tweet, or is made aware of a tweet by David Gingras, where he threatens her with a defamation lawsuit. And after that threat had came out, there was this tweet from Legal Vices, 1857.
You could have just copied and pasted it.
I literally asked you how to do that, and you were silent when I asked. And so I just typed it in myself. So this was a Legal Vices response to David Gingras in real time. He wrote this.
You're going to show your screen or no?
Yes, I will. If I could, how do I get this on the same plane as this? You know what? I'm going to put it over there, and then I'm going to drag it.
Drag it on top, yeah.
Well, what if it doesn't work like that?
Are they two different browsers?
No, there's two different open here. There we go. Now it's up. So he says in response to what Gingras says, David, as lawyers, we both know and appreciate that words mean things. So just a few comments that I have for consideration. And I've asked David, like, what does JFC even mean? Like, you say it's this cult. What is that? What are the requirements? What's the membership requirements? It says, I think it's important to define terms so that everyone is on the same page. Who or what is considered to be a JFC YouTube person? How do we define that term so there is clarity and no disagreement as to whether a person is or is not a JFC YouTube person? Number two, Clayton's Justice referred people to Lethal Lauren 904's YouTube video. How could Clayton's Justice be subject to a copyright strike for recommending someone watch a YouTube video? Which is true. How do you go about copyright striking a Twitter post from a person without a YouTube channel who is recommending people watch a YouTube video? And by the way, in real time, Gingras posts a receipt for his attempt to copyright his own video. The problem with that is on YouTube, under their terms of service, if you haven't copyrighted already and you post it to YouTube, they own the copyright. So he's going to have a competing copyright claim with YouTube. I don't know how that works. I just know that there's a dispute as to whether or not he's actually copyrighted his own video. Point number 3, even if you really hate someone, especially if they are a JFC YouTube person, whatever that term is eventually defined as meaning, and that person posts a perfectly legitimate fair use review commentary of your video on YouTube or wherever, and I'll define exactly what that means according to the law in Arizona, because that's where Gingras practices. Do you really actually plan on issuing a copyright strike against them for using any part of your video, any including all of it? I know you understand that. As mentioned by Panda for You, that would constitute a false copyright strike, which could subject you to channel banning by YouTube. Let's not do that. Nobody wants that. Gingras just started his YouTube channel. He's got like 242 subscribers. So that short video, and he's talking about the teaser video, I think on Twitter, objectively not a good look. I understand that the purpose and intention of that video was. However, this is Twitter where your tweets go out to potentially everyone on the platform. There's going to be tons of new viewers who have no idea about this case whatsoever, and their first introduction to you, your client, in the case is, hello everyone, it's Douche Canoe and Pregnancy Faker. That's literally how he opened the video. Priyanka's sitting here like, what the fuck are you talking about? Trust me on this one. It is a case. It involves allegedly false, faked pregnancies that were used to bring a paternity suit in Arizona that it has been accused of the person that brought the claim to have weaponized the court system to coerce a relationship with a gentleman named Clayton Echard. Clayton Echard, if you don't watch The Bachelor, was the Bachelor. I don't know. I don't watch that show either, but he was the Bachelor, like the guy that everybody was vying for. So she has a relationship with him, claims that she's pregnant. Mind you, they never, according to Clayton Echard, had vaginal sex. It was only oral sex, but somehow she had a positive pregnancy test. She opens in a paternity case in Arizona, tries to withdraw it a few months later in December, claiming, oh, I'm not pregnant, actually. But then they said, oh, no, you're not going to let you dismiss that, because they wanted to go after sanctions, and they had this whole trial back in August. That's what this is all about. I gave you the super summarized version of it, but in a nutshell, that's what this case is about. So his number 4, it's the old catching flies with honey or vinegar thing. Just because you are a zealous advocate for your client, which you are ethically within certain boundaries required to be, and to which she is entitled to have, you don't have to be so constantly confrontational. I've told David that myself. Like, what? Like, why? Like, why do you got to be such a dick? Like, why can't we just all, I mean, could we get past the initial whatever? Like, all right, you don't like me, I don't like you. Now let's move on and talk about something meaningful. But he's threatening people continuously on numerous occasions over the course of a large-ish timeline. It's just what he does. So fighting fire with fire works, but fighting fire with cool, soothing water tends to work better. And I agree with that, man. There's I don't know what your parenting styles might be. I have a 4 and a 5-year-old. If you yell at them and try to discipline them that way, and you're the big scary parent, and enforce your size and the depth of your voice to try to impose upon them some kind of understanding of what you want them to learn, it's not nearly as effective as when you talk to them like your friends, hey, you can't punch your sister in the face because it hurts really bad. What if she punches you in the face? You wouldn't want that, right? No, you don't want to hurt your sister. I don't. But you did hurt her. Look at her. She's crying. I'm sorry. Well, could you give her a hug and say you're sorry? Okay. And then they learn the lesson that way. The cool, soothing water that Legal Vices is talking about. He concludes this post as officers of the court, I think we should always try to be better. Just some food for thought. That's all. That's all. And then he left, which brings me to my next point. Let's talk about these copyright strikes. So, this is the law, essentially. This is the law. If a content creator, I almost spilled my whiskey. That would have been a party foul of all party fouls. If a content creator obtains a copyright for a video that they produce and threatens to sue anyone who uses any portion of the video, the likelihood of their success in a lawsuit against someone who makes a YouTube video commenting over the entirety of the original video under the guise of fair use depends on several factors. And I think Gingras even alluded to this in a post that he dropped this morning. So the Copyright Act of 1976, specifically Section 107, it incorporates the fair use defense to copyright infringement. This section provides that the fair use of a copyrighted work for purposes such as criticism, comments, news reporting, teaching, scholarship, or research is not an infringement of copyright laws. In this case, if the YouTube video is genuinely offering opinions about the specific takes in the original video, which it unequivocally was, and is for educational purposes, it may qualify as fair use, which, by the way, I think that video that Lauren dropped was like 2.5 hours long or something like that. I literally went on her show and talked for 30 minutes, countering some of the points that Gingras was making in his video, explaining why I disagreed with his take on the appellate issues, because there was a fundamental misunderstanding in civil courts where you have a right to dismiss what you know or have been proven to be a frivolous complaint through the course of litigation. You have every right to walk that back if you have notice that they intend to pursue sanctions based on a specific statute. He tried to play by that rule in family court, but what he doesn't and is failing to recognize is that in family law, the courts have the inherent discretion to punish bad behavior. If the court believes that a party frivolously brought a paternity petition, knowing that they weren't pregnant at the time, then the court has every right to punish that behavior regardless of the civil rules that he claims, and I'll go into that in a bit. My only point in mentioning that is on Laura's video, specifically, she was countering those points. That 100% already throws it into the spectrum of fair use. It is not suable. It's almost, if you were to bring a lawsuit like that, it's almost an MSJ, motion for summary judgment. Look, Your Honor, here's the transcripts. Here are all the points where she's basically disagreeing with him. Here is the transcript of another commentator that came out to give differing opinions for educational purposes. Case open and shut. There's no reasonable jury that's going to find for the plaintiff in that case. Case dismissed. I'm not concerned, therefore, about threats of a $150,000 lawsuit with respect to Lauren Knighty or to Dave Neal or to Megan Fox or to any other creator, Legal Vices, myself, that chooses to use any of Gingras' content that he publishes on a public platform such as YouTube regarding a case that has garnered a specific set of public interest. I'm just not worried about those kinds of lawsuits because virtually all of those content creators are doing it specifically for the purpose of countering his points, which is the definition of fair use. So courts typically decide considering 4 factors when determining whether a use is fair. So the purpose and character of the use, including whether it is of a commercial nature or for nonprofit educational purposes, the nature of the copyrighted work, the amount and substantially of the portion used in relation to the copyrighted work as a whole. And keep in mind, it doesn't matter if whoever content creator uses the entire video, so long as they're providing something extra to the video so as not to completely steal the original creator's content. And there's cases where that happens, and the law is pretty well developed in the differentiation between the two. So there's that, the nature of the copyrighted work, the amount and substantially, I read that part, didn't I? And the effect of the use upon the potential market for or value of the copyrighted work. if the commentary video is transformative, meaning it adds new expression or meaning to the original work and does not merely supersede the original, it is more likely to be considered fair use. Now let's take that and apply that to Lauren's situation. And I'm going to use Arizona law because that's where Gingras practices. This would be probably a federal lawsuit if you brought it in. The same rules would apply, but I'm making it specific to Arizona on purpose. So courts in Arizona do not have a specific statute or a rule that directly defines fair use in relation to YouTube videos. The provided document, Arizona Supreme Court R-122, primarily addresses the conditions under which a judge may deny or limit media coverage in court proceedings, focusing on factors as the right to fair trial, privacy, safety, dignity of proceedings, blah, blah, blah. So while this rule outlines the consideration for media coverage in courtrooms, it does not provide a definition or guidelines for fair use content. Fair use is generally governed by federal law, 17 U.S.C. 107, which considers those same factors. So in analyzing the fair use implications, I sent this to Lauren last night to kind of ease her mind a little bit, of a YouTube creator using the entirety of a lawyer's video, which she did, about an appeal in a public interest case while providing commentary and differing opinions. Several factors must be considered under the fair use doctrine. These factors include the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use on the potential market for a value of the copyrighted work. First, purpose and character of the use by the YouTube creator, namely Lauren Knighty, appear to be transformative, as the creator is providing commentary and differing opinions on the lawyer's video, the lawyer being David Gingras. Transformative use, which adds new expression or meaning to the original work, is generally favored under fair use, Arizona Rules of Professional Conduct, Rule 3.4. Fairness to opposing party and counsel. The fact that the video is used for commentary and criticism, which are recognized purposes under fair use, strengthens her argument. Secondly, the nature of the copyrighted work is also relevant. The lawyer's video is likely factual in nature, and it is. It's factual in what he's filed, and it's also expressing his legal opinions about where it's going to go. Discussing an appeal in a public interest case, courts are more likely to find fair use when the original work is factual rather than creative. 44-1448.01, injury to business reputation dilution. By the way, I'm getting all this off of my Lexis search into the specific fair use rules in Arizona where the video originated. So this is basically me citing case law. So third, the amount and substantiality of the portion used is a critical factor. Although the YouTube creator used the entirety of the lawyer's video, courts have recognized that in some cases, using the whole work can still be considered fair use, especially if the use is transformative and for purposes such as commentary or criticism. Again, Arizona Rules of Professional Conduct 3.1, meritorious claims and contentions. Lastly, the effect of the use on the potential market or value of the copyrighted work must be considered. So if the YouTube's creator's use of this video does not significantly harm the market for the lawyer's original video, this factor may also weigh in favor of fair use. And by the way, David Gingras' YouTube channel is not monetized. He's not eligible to receive income through YouTube, at least through YouTube specifically. So that wouldn't really, I don't even think that he could even make that claim, that there was somehow damages with respect to what he deems improper use. Arizona Rules of, what did I lose? So basically, in conclusion, he could sue if he wants to, he's not going to win. In other words, unless Lauren represented that David Gingras's, the contents of his video were specifically derived from her own creative work and try to take credit for it directly, he can't win that claim. I'm not even sure if he could claim ownership, even if he tried to copyright the video after he already published it to YouTube. I'm not even sure he would have standing to bring a lawsuit at this point. So those are issues specifically to that video. As to it pertains to fair use, anybody that references any content that's been put out by Gingras or anybody else and uses it to comment on, offer differing opinions, transform it to their own devices, whatever, it's fair game. You can do that. And look, there is no greater developed area of law than copyright protection. If what Gingras is saying is true, then you'd have to get rid of like 80% of what YouTube is, which is mostly reacting to other things that happen in the media, in popular culture, whatever. Lauren Knighty is safe. I have no fears that Gingras would be able to prevail on her. And if he's looking for $150,000, good luck with that, because as she says, her net worth is like negative. And so basically, it's a tactic to bully and be a dick, which he full well knows. He knows that. He knows that. I know that he knows that. He's told me. Frank, you're looking at me like this confused face. Did you have a comment?
Yes. So I think when you post something on YouTube and you are actually commenting, it does fall under fair use, but the issue is whether she is receiving any money by posting that video on YouTube or not.
So the rule is you're allowed to make money off of that. For example, you can't really use like people that cover court trials. Like, for example, people like do reviews on movies. They do reviews on other content creators' video. You're allowed to do that if you are basically substantially making it your own content. Meaning they're posting up their opinions. I got different opinions. Or let me give my opinion about this performance. You're allowed to do that because it's protected free speech. You can't do that. It's why we have, and people that tried to sue for that kind of thing, it's why we have these anti-slap laws. And there are anti-slap laws nationwide that protect that form of speech. And so if the purpose of your defamation lawsuit is specifically to shut down the opinions of somebody else, that's bullshit. You can't do that. And there's severe penalties for that.
That's true. I mean, it's not going to be a defamation lawsuit for sure, but when you go to court to argue fair use of a work product, then it becomes that you have taken that entire work product and then you have commented on it. You are stating for educational purposes or for criticisms, but you are actually also getting money out of it. So then one of the clauses of fair use is not met.
And you're right. And so one of the arguments we'll make that she's not allowed to profit off it. But guess what? YouTube kind of takes care of that. You put a copyright strike on someone's video, they demonetize your video. Any money goes to the original creator. It's usually what happens. She specifically demonetized the video herself. And so if he wanted to do it on the basis of that video, he doesn't even have that argument because she's specifically not making money off of it. And she's directing traffic towards his video. And even if you could say that that's not fair, there's no law that says that you can't make money off of your opinions of other people's work. There's just not. There isn't. And so there's exceptions to everything. It just doesn't apply here. You see a lot of, Tiffany says, H3V Matt Haas lawsuit set precedent. I don't know what that case is genuinely, Tiffany. I'd have to read up on it. I'm just saying that in this scenario, the chances of him prevailing on appeal is like zero. Zero. Unless he could prove certain things that he's not going to be able to because she demonetized the video anyway. Plus, her video is like 2.5 hours. His original content was 48 minutes. It was literally an hour and a half extra of her adding her own stuff into it, her own opinions, talking shit to like her audience members, having me call into her show and do different things. They had nothing to do, some of it with Gingras, some of it did. The point is that she is constitutionally protected, as are any YouTube creator, in using those videos, snippets of it or the entirety of it, to offer her opinions, especially because it's a case of public interest. It involves court proceedings, which are largely public by nature, unless there's a specific order not to make them public. Well, I don't have a third point. Just those 2 points alone are enough. Cat Lady Ballerina, thank you so much for the $5. I'm cheating on my work call. It's playing in the background, but I'm really listening here. I appreciate you. Jason Hipsher, what a name. Says and thank you so much for the 5. Says Lauren has nothing to worry about. I'll take care of my friend. Gingras is awful. I got Lauren's back too. She's safe. She's safe. I don't think that she has anything to worry about. And I've shared my legal opinions as to why. And I think I already got to Angel's comment.
That's a second one.
Oh, it is. Hey, Angel, thank you so much for another 10 Tilted Lawyer memberships. It is greatly appreciated. That's the best way to support this channel. So listen, as to the bullying and the threats to Dave Neal, to Megan Fox, to Lauren Knighty, to anybody else that might have been included in all of that, I just wouldn't worry about it too much. There's not much bite to that lawsuit. It feels like something that would be defeated in an MSJ, a motion for summary judgment. And I think that you'd be able to point to, by the second, every instance where you inserted your own original opinion, your own original commentary, and defeat that pretty easily in a federal lawsuit or a local lawsuit in Arizona. That's just how I feel about it. And Gingras can disagree with me if he wants to. I'm sure he does. I'm just not worried about it. So listen, the crux of, let's talk about Gingras and his appeal. Let me break this down for you, Priyanka, because you practice family law. I know this. You and I just did a trial together. So what if I told you, let's just say that we had a trial. And let's just say that your client has allegedly faked a pregnancy. You don't think that she faked a pregnancy, but the other side thinks let's say that I think that she faked a pregnancy and therefore brought a paternity suit. Let's just call it California, in bad faith. She does that. And then 4 months later, say in December, she files in August, tries to dismiss in December. Let's just say she does that and wants to dismiss, claiming, oh, by the way, I'm not pregnant anymore, so I want to dismiss. And then I say, no, bullshit. You were never pregnant, and I got the proof right here. Your Honor, I'm asking for sanctions and monetary awards for her shitty behavior. In our state, it would be under 271. Under they got their own laws. And then you try to dismiss, like, no, I'm not going to be sanctioned. I'm dismissing everything. I have a right to do that. And then the judge, has to make a ruling. What do you think the judge would say?
I think the judge will dismiss it without prejudice. And I can say that since I have to represent my client, and my client brought the paternity action stating that she was pregnant. And my argument would be that, she did not get her periods that month and she was going through her, there was some problems in the hormones and you cannot really, and she did not get her periods for a few months and she did think she's pregnant. She later on got her periods.
I'll grant you more than that. Not only did she not get her periods, there was multiple positive HCG tests that suggested to a 99% certainty that she was pregnant. The allegations by respondent is that she faked the HCG test, that we never had vaginal intercourse. We only had oral, and claimed she got pregnant off of that. I was in disbelief. She came and peed on a stick right in front of me, and son of a bitch, it came back positive. What I've come to learn is I try to ask her for an ultrasound. I try to ask her for all these tests. I try to go to her to her prenatal visits, try to do all these things. She kept blowing me off. She never confirmed a valid ultrasound. She sent me pictures of fake ultrasounds. She doctored evidence. By the way, she did doctor evidence. It was admitted at trial. She doctored ultrasound images. She did a number of different things that led this specific court to believe that it was dirty, that what she was doing was dirty. In addition to all of that, there was emails and text messages that went tantamount to this. Look, if you don't want to date me, fine. I just want you to know I'm keeping the kid. I know you want me to get an abortion. No, fuck that. You don't want to date me? I'm keeping the kid. And by the way, it's twins. She claims she was pregnant with twins. And then she says, but if you do want to date me and give me a chance, I feel like you'll get to know me and change your mind. If you decide to date me, I will get an abortion, just as you requested. And then she says, remember that I said they'd never had vaginal intercourse. She then proceeds to say, I just feel like if you felt how tight I am, you would change your mind about me. I'm paraphrasing. I kid you not. That's what she said. It was in an email that was submitted as a court exhibit. Okay. And the judge knows all of that. And the respondent moves for sanctions on what appears to be her knowingly filing a false paternity petition, knowing that she was never pregnant. She was faking it the whole time. And then she tried to dismiss it after it was no longer going to work. And now he wants sanctions. He's like, no, you can't just dismiss. I want her sanctioned. I want monetary sanctions. I want her to essentially pay, right, in the family court. What would you say about her ability on those allegations to dismiss? You could dismiss the paternity claim. I agree with that. But now we have a different motion, and the motion is for sanctions. What do you say about her ability to dismiss the motion for sanctions in that regard?
So again, the burden of proof is then on the respondent to show that they did not have vaginal sex.
Absolutely right. You're 100% right. The burden is on the respondent by clear and convincing evidence to basically prove fraud, right? I think the actual burden might actually be higher than that. But you're right. But what doesn't get to happen is you don't get to just dismiss, like hand wave away. It's like, oh no, she was just kidding. She's not pregnant. She dismissed. And so he doesn't get to sue me for sanctions because I'm not pregnant anymore. I already dismissed my petition. So one of the appellate issues is that she had every right to dismiss the petition without him being able to sue for sanctions, essentially, is what the argument is. He's claiming because in civil court, usually in civil court, well, 100% of the time in civil court, if you are giving a specific notice that people are going to go after you for monetary sanctions, punitive damages, or whatever, because they believe that you now have reason to believe that you're litigating in bad faith, you have like a 10-day period to withdraw or else, right? He's trying to apply that civil rule that in federal court and state courts, they all have their own rule. He's trying to apply that rule to a family law case where somebody is now asking to sanction somebody's bad behavior. It doesn't apply there because the court has every right to punish bad behavior according to whatever they want to find. It's like I said, for us, it's Family Code 271. Anybody that disrupts the ability of the parties to move the case to settlement, to resolve the case, that acts fraudulently, that is being a dick, pretty much, right? The catch-all. It's the catch-all, 271. That was the nature of the sanctions request by Clayton Eckerd. It was granted, by the way, to trial. So his appeal is essentially this. When she tried to dismiss in December, she had every right to dismiss the case. And this case should not have been allowed to go forward on the very simple premise that she was no longer pregnant, and it was proven at trial that she had a somewhat of a basis to believe that she was pregnant. And really that was the standard. Because I had always said, all she has to do is make it make sense to the judge. Just make it make sense why you actually thought that you were pregnant. The evidence that proceeded to come out, and by the way, this was like a nutty case. They literally had 2 hours for trial, both sides, and it was a hard 2 hours. It was like, you got an hour to present your case. Get your witnesses in. They were like, there was no going over the clock. I mean, strict 2 hours, right? I don't know if you ever done a trial like that. I've never had a trial like that, where it was like a strict time limit, like the buzzer goes off and we're done.
No.
That's what they did. So anyway, after a full trial, after a full year of litigation, basically, the judge made a finding that, yeah, I think that the petitioner behaved poorly here. They awarded damages to the tune of, I don't know, it was like $150,000 or something to that effect. That was basically this case. And you're brand new to this case. And so, which is really cool because most people that come watch me talk about this case have been invested with it for like a year and a half. So anyway, this guy, Gingras' video focused on these things. He says, when he's describing his appellate issues, he argues that the judge in the original trial was biased against Laura. He claims that the judge made rulings that were favorable to Clayton and that she may have based her rulings on information from the Justice for Clay website. There was not really any evidence of that other than this one particular piece of evidence that had to do with when a Planned Parenthood facility, the hours of operation, and when it was actually open. It made its way into Judge Mata's ruling. It never came out in trial. And I don't even think that it came out in any of the prior exhibits. And so he's claiming that Judge Mata made partially some of her ruling based on information that was outside of the court's records, right? So on the strength of that, that's one of his issues for appeal. What has been ruled in the interim is basically that minute issue was so tangential to the rulings to be insignificant that it wouldn't have made a difference. So basically they don't care. He's lost. He made a motion in the lower courts. He's going to take it up again on appeal. They're going to make a decision on that. He also argues that the judge violated Laura's rights by denying her motion for a new trial with her notice of change of judge was pending. So there was a motion for a new trial based on unfairness after she lost in June. There was also a motion to remove Judge Mata for her bias. While that motion was pending, she denied his motion for a new trial and then was like, oh shit. She later, I think, withdrew it and it was denied anyway by a different judge. But that's another issue that he had brought up on appeal. But it's essentially this. The main crux of his appeal is Gingras believes that Clayton had no right to continue the case after Laura moved to dismiss it. He believes that the appeals court is going to agree with him on this point and that the case is going to be dismissed or sent back or whatever he thinks is going to happen.
I don't actually agree with that because in appeals, again, Clayton has to prove that why he's asking for sanctions, the burden of proof is still on him. And if he proves that, then I do not think that argument stating that, well, once she dismissed the case, Clayton should have just moved on and not asked for sanctions is not going to have any value.
You're exactly right. And so the judge's opinion, and mind you, when she got up on the witness stand, it was a mess. Her story, what she had said in pleadings, it literally changed on the stand.
Oh, well, we know how that works.
Yeah, and so her credibility was shot. There was competing experts in the case, and one of the experts came in and said, with respect to pregnancy, the positive HCG test, there's multiple reasons why an HCG test comes back positive. It could be a spike in certain hormone levels. It could be a number of different things. It's not necessarily dispositive of pregnancy. Yeah, most of the time it means pregnancy, but you could also elevate it. Or fake an HCG with elevated levels of certain things. I forget what they specifically said. But what Clayton Eckert's expert came in and said was, you don't just take one or two HCG tests. Pregnancy is confirmed after after you have a series of HCG tests. After a specified period of time, where you have consistently elevated HCG levels that lends itself to a pregnancy. And even then, they do a vaginal ultrasound and confirm. Oh, look, there's a little fetus right there. Or what do you call it? Like a zygote? I don't remember. Biology class. I'm not going to ask you. You don't remember either. Doesn't sound like
I
you
don't,
do.
but I think it's still called a fetus. It's just not.
Anyway, there was competing experts. The judge believed Clayton Eckert's expert over Gingras's expert. Mm-hmm. He believed in the merits of Eckert's case over Owen's explanation. Owens gets up there and testifies. Eckert never got up and testified because they just didn't have time. Most of their time was devoted towards expert testimony and cross-examining Lower Owens and such. So, but he did give prior testimony, essentially outlining that he believed, with his whole heart of hearts, it doesn't make sense that she's pregnant. We never had vaginal intercourse. She told me that she was pregnant. I didn't believe it. They had full-on depositions like testifying to that fact. He claims that they were like, the specific claims don't matter. The point is, he believed in his heart of hearts that she was faking it. He had no reason to believe that she was ever pregnant. They never had sex. They had oral sex. You can't get pregnant that way. He wasn't allowed to see valid ultrasounds, and the ones that he was sent were verified as doctored and faked. And she admitted in the pleadings that she doctored some of the ultrasounds.
Okay.
And so the judge is like, okay, so I mean, that's, if you're asking for, prove to me that she faked a pregnancy. Your Honor, I literally have fake ultrasounds that she sent me, that she, and then the other party, yeah, I faked them, but that was because he was being a dick or whatever she said, right? And then she's changing her story on cross-examination. The trial was a disaster. So if you're looking for somebody to believe, I don't know of many judges that would not find that Eckert met his burden of proof in demonstrating that it was likely a false pregnancy and that she knew that it was a false pregnancy and she brought a paternity case anyway. And in the judgment, he was awarded damages ultimately. That's essentially the case, right? So before we even get to any of that, what Gingras wants to do is say, look, you shouldn't have never got that far. She wanted to dismiss back in December. In December, she knew beyond all shadow of a doubt that she was not pregnant. She tried to dismiss. They wanted to keep this thing going, asking for sanctions and this and that. My client has a right to dismiss. You can't ask for sanctions, and he cites this rule. I'm going to talk about the legalities of that rule because your instinct is correct. You've been practicing for how long?
2.5 years.
2.5 years. So you're still like a baby-ish attorney. Yeah. So you're getting to this point where you're starting to, you know what I mean? Oh, I remember when I was a 2.5-year-old attorney, I was terrified. I was driven by my insecurities. My insecurities caused me to dive deep into all of the law, case law, whatever. And oftentimes, even then, I was wrong. There's just such a difference in your interpretation of what you think the case law says versus how it's actually practiced. And finding a way to marry those two together is really the challenge. Some attorneys are quicker than others. It took me probably a good 6 years before it felt reasonably comfortable, and maybe a good 4 years after that before I just said, whatever, it is what it is. Nobody gives a shit. You guys aren't really paying attention anyway. I've just started having certain opinions.
Well, fake it till you make it.
Well, that's what else are you gonna do? You can't. Well, Your Honor, I don't know. Whatever you think. Just the law says. All right. So let me just break this down. So he cites. Well, let me break down his legal argument first. I'm not going to play his video, not because of the copyright infringement fear. I just wanted to expedite this video because we got other things to do. So this is what he argues. This is from his video. These are the notes that I took. David argues that Clayton cannot recover fees under Rule 26 because he failed to follow the rule's strict requirements. He believes sanctions are unwarranted because Laura did not engage in unreasonable litigation conduct. That's a matter for interpretation of the judge. You could say that, but if the judge believes all this other evidence that suggests that she did, what are you going to do?
So remind me, when did she bring the action?
August.
And she dismissed it in December.
December of 23.
Well, that's a long time for her not to be sure that she's not pregnant, and she continued to pursue it.
One of the things that the judge had noted was that, look, you say that you're pregnant, but you didn't go to any of your prenatal care visits. You went to like a couple of these here and there. Most people, when they're pregnant, tend to go to the doctors all the time and get, prenatal care. They're taking prenatal vitamins. They're doing different things. They have valid ultrasounds. She was not able to produce any, what the court deemed valid ultrasounds that were not doctored. What is the court supposed to believe? If she would have showed one shred of evidence, just give me one shred of evidence where I could see where you reasonably thought you were pregnant.
Did she actually call any doctor to testify? I mean, those documents are hearsay.
Yeah, and what the doctor said, who was retired, by the way, he wasn't even a practicing doctor. I think his name is Judge or Doctor, I forget his name. But what he said was, well, if you got an HCG test, that's 99% usually reliable. But then there was a practicing doctor that came and said, yeah, that's not the end of the story. You can't base it off of one or even two HCG tests. Or multiple. There have to be a series of HCG tests over a period of time that demonstrates the earmarks for pregnancy. And even then, we're going to go in there vaginally and look and take a video and have visual confirmation and all these things. And I don't know if you've ever been pregnant or not, but like there's an extensive prenatal care schedule that most pregnant women go through. Laura Owens did not. And then there was games like, oh, I have an ultrasound appointment for such and such a date. It's like, okay, well, let me go. And then she's just canceled it. Why did you cancel it? Because I was afraid that it was going to go there and make a scene. What are you basing that off? If you want to go to the ultrasound, it was like just these weird excuses for why things didn't exist so that the judge just didn't trust her. She's obviously, and by the way, she's still claiming to have legitimately been pregnant. I haven't seen any evidence that corroborates that. I've stopped having the evidentiary discussion with that side just because, look, the evidence is what it is. There was a full trial. The evidence came out the way that it did. I haven't seen anything in the aftermath to lead anybody to change their mind. And so I've just kind of left that alone. I focus squarely on these appellate issues. So they can hold that belief if they want. Just the mountain of evidence is contrary to all of that, is the point. So continuing on with his reasoning. Hey, how am I doing on time, Dominic?
You have 56 minutes now.
Holy shit. Oh, time flies, doesn't it? Okay, so David claims that there are strict requirements. He asserts that Clayton cannot receive sanctions under Rule 26 because he failed to follow the strict requirements of that rule, and there is no pending Rule 26 motion, which there wasn't because they moved to dismiss the Rule 26 motion, I believe is what happened. And they were basically just running on general sanctions for bad behavior, which they have every right to do in family court. It's a pretty common thing, I think, across all 50 states. The family court has a right to punish bad behavior as they see it. They're not beholden to civil rules of procedural requirements of dismissing lawsuits. Lawsuits and paternity petitions are very different. And so, anyway, without going too far into that, the specific requirements of Rule 26 in this context, he didn't elaborate on specifically what he's talking about, but I'm going to in a minute. He emphasized that Laura's good faith in initiating the lawsuit based on her belief that she was pregnant. He details the reasons behind his belief. Multiple positive pregnancy tests, the cessation of her menstrual cycle, like you had mentioned. There was weight gain. There was physical symptoms associated with the pregnancy. The problem with that is Eckert produced other evidence that gave explanations for that. Motion to dismiss and lack of further action. He highlights Laura's actions after discovering the pregnancy was likely non-viable, requesting mediation. There was a motion to compel lunch.
What?
I kid you not. That's the title of the motion. Motion to compel lunch and further meet and confer, whatever it was. It was a title of a motion. I was as baffled as you are right now looking at me like that. I'm just saying, it was a thing. Ceasing further action, ultimately filing a motion for voluntary dismissal. These actions demonstrate her intent to end the litigation promptly upon realizing the case was moot. The problem with that is he's basing that on the court making a finding that she brought this in good faith. The reason why Eckert was awarded monetary sanctions is because they fundamentally found that she did not bring it in good faith. Matter of fact, this case was referred for prosecution up in Arizona for perjury and possible illegal extortion on unrelated matters. I don't got the time to go over it right now. Just trust me, there's a lot more than what I'm saying right here going on. So, he highlights Laura's action. Yeah, I talked about that. So David contends that any fees Clayton incurred after December 12th, 2023, when he decided to not let her dismiss and go for sanctions, were not due to Laura's actions. He points out that Laura's counsel promptly moved to dismiss the case upon being retained. If Clayton had engaged in the required meet and confer process with Laura, he would have realized the mootness of the situation and avoided unnecessary expenses. David did tell me that he tried to meet and confer with Eckert's attorney, Whitnick, and it just didn't work out. They were pissed. They wanted to go for sanctions. Imagine Eckert was your client. What would you do?
Yeah, immediately I would move for sanctions.
Yeah, if you had all of that proof, what would you do? Of course you're going for sanctions.
And especially where she admitted to have doctored it under penalty of perjury. And then
she had her reasons. Her reasons were, well, people were making fun of me online and I felt like I needed to come with some kind of evidence and I was getting nervous. And so
go to an ultrasound. That's the evidence.
And so,
you're right.
And so, look, whatever explanation, it wasn't satisfactory to the court is the point, right? So his stance is whatever his fees incurred from December was his fault. He's the one that wanted the sanctions. Yeah, no shit. Of course he wanted sanctions. So his argument hinges on framing Laura's actions as reasonable and in good faith, while portraying Clayton's continued pursuit of the case as the primary driver of these unnecessary legal costs. If I were to give you Laura Owens' case and I were to tell you to make that argument to me and I'm the judge, how would you feel about that?
I would be nervous.
Would you feel confident in your ability to prevail?
Right now, I would have to say no, primarily because, I mean, there can be false positives, of course. There is a chance. But right now, if not anything, at least AI has developed so much that all she had to do was go to a doctor and just get it done. Get a check done. That's it.
That's kind of been the crux of, like, he labels this the JFC community, Justice for Clayton community. There was a community of individuals that became infatuated with this case, knowing that they believed that Laura Owens had coerced Clayton Eckert and to try to coerce him into a relationship and dragged him through this paternity test and just basically turned his life upside down as a result of what everybody believes based on all of the evidence were false pregnancy claims on the part of Laura Owens without any evidence. They've been asking for any genuine evidence that would lead anybody to believe that she was genuinely pregnant. The best that they've been able to do, as far as I'm aware, is these HCG tests that an expert came in and said, yeah, that's not the final story. We need like a genuine ultrasound. We need this and we need that. If you were to be pregnant, I don't know, do you have children?
No.
So you've never been pregnant. Let's just say you were pregnant. If you went to your doctor and he prescribed a common round of prenatal visits, like say every couple of weeks, let's just check on things, whatever, prescribe prenatal medications, would you just like say, no, fuck that. I don't like the doctors. I'm not going to go.
Absolutely not. I mean, first of all, I would imagine when I get pregnant, I would be freaked the couple of months with the hormonal changes and everything. So I would like to follow my doctor's advice and go to the visits.
Yeah. By the way, there has been multiple other allegations that Laura has similarly faked other pregnancies with other men. I'm not even going to begin to get into all of that. Let me just tell you that it has been alleged that there is a pattern of behavior where we can't really take this as her acting in good faith, is all I'm going to say. So let me break down the law in Arizona as it relates to this Rule 26 thing. So family law, first of all, family law Rule 26 in Arizona, it primarily addresses the discovery process. But for a litigant who brings a paternity suit, they have the right to dismiss their suit on the grounds that they are no longer pregnant. They have that right. They can. However, if the other party believes that the litigant also knew she was not pregnant and brought the suit in bad faith, they can challenge the dismissal, meaning they could not allow it to go forward because of everything that we just said. Behavioral sanctions, call them that, right? Sanctions for acting in bad faith, most common grounds, right? They can be challenged. The courts have inherent authority to set aside judgments for fraud on the court or jurisdictional defects, even after termination of a parent's rights and adoption of a child. There's this case, Angelica R. versus Popco, 253 Arizona 84. There's another one, McKellen versus Hufford. In Arizona, it is established that one who has knowingly and intentionally perpetrated a fraud on another party and the court can never be entitled to relief under Rule 26 or any other proposed rule under civil law or federal civil law that dictates that they should have that kind of relief. It's an exception to those rules, and it's unique to family law. It appears in Arizona anyway. So I feel like the case law is well written over there in Arizona, and I think that Gingras is wrong. And when I talked to him about this, I asked him specifically, he's like, okay, I get what you're saying, But what about behavioral sanctions? What about the court made a finding that an individual or a party to the case was behaving badly? Do they not have the inherent right to sanction that individual regardless of whether or not there's any pending litigation? Matter of fact, I'm pretty sure they can make it on the court can sanction an individual or a party on their own motion if they really wanted to. And in this case, Judge Mata, on her own, forwarded this case to the Arizona Maricopa District Attorney for potential prosecution and perjury charges based on what she saw in the litigation. So there's that. What do you think about all of that?
Wow, that's interesting. So what I'm confused about is when you spoke, why does he think that Clayton does not have the right to sanctions just because he dismissed?
This is as simple as it gets. In civil law or in federal civil law, the simplest way I could put it is if the plaintiff in a civil case finds out that there is no factual basis to continue in the litigation, then they have every right to dismiss the lawsuit without penalty if they are given notice that the defendant in the case knows about there's no factual basis or believes that the plaintiff acted in bad faith and intends to pursue sanctions in that case. They have, if they're given notice by the defendant, then the plaintiff has like a 10-day period in most cases to dismiss the case without penalty. And oftentimes civil plaintiffs' attorneys use that rule as like this blanket to bring whatever case that they want to bring because they don't know if it's a legitimate lawsuit or not. They might find during the course of litigation that their client is a liar. And so it protects attorneys and it protects litigants if they're given proper notice that there are going to be sanctions pursued upon them or other monetary penalties to dismiss without penalty. It protects attorneys. It protects people. It's designed to advance litigation. There's a number of different legislative reasons why it exists. But those protections are not the same in family law because there's a loophole. It's not even a loophole. It doesn't take into account that family law judges can, with or without a moving party, sanction parties to a case for bad behavior. That is the law, and you can't change it. David Gingras, I didn't realize it before, and it should have made more sense. But he's not primarily a family law attorney, so it wouldn't make sense to him that the family law courts can do this. And there's a reason for it. There's limited exceptions, right? Like, for example, if you have a client and they want to bring a restraining order, and the temporary restraining order gets dismissed, for example, they could dismiss that without any penalty to them, without the other party ever knowing that it was even filed. That would be like a small exception to that rule. But if the other party is forced to respond, they no longer have any right to dismiss anything if the other party wants to pursue sanctions for bad behavior, such as what Eckert did. That is a fundamental principle in family law as it pertains to California, and it looks like it's mirrored in Arizona, which is where this case originated. So let me go even deeper into that. So family law rule 26 in Arizona does not directly address the respondent's right to challenge the dismissal of a paternity suit. However, it provides guidelines on the discovery process, including considerations for undue burden or expense and good cause factors for discovery or disclosure. It's mostly like it's a discovery statute that they have. Yeah. In the context of challenging a dismissal, Arizona Family Law Rule of Procedure 46 is more relevant. This rule allows a responding party to move to dismiss an action if the filing party fails to take necessary steps to resolve the case. The court may also dismiss a case for failure to move it forward, but it must give all parties notice and an opportunity to object or proceed with the case. So importantly, the court cannot dismiss a paternity case if there is a pending motion related to, say, for example, genetic testing, or whether or not she ever believed she was pregnant, whether or not she perpetrated a fraud on the court. That is according to Arizona Family Law Rule of Procedure 46, as it relates to dismissals. Additionally, in Arizona, specific to Arizona, under 25.324, attorney fees provides that if a petition is filed in bad faith, not grounded in fact or in law, or for an improper purpose, perhaps to coerce a relationship out of the bachelor or whoever, the court shall award reasonable costs, shall, not may, shall award reasonable costs and attorney fees to the other party, and that's under 25.324. This statute supports the respondent's right to challenge the dismissal by potentially recovering costs if the suit was filed in bad faith and he was awarded those costs. So he's bringing up the issue on appeal. So based off of solely Arizona, look, Gingras says he's pretty confident that he's going to prevail. It just appears to me that the case law allows for judges to do what Judge Mata did, which is sanction what she deemed or interpreted based on the evidence to be Laura Owens' bad behavior. And so he's got an uphill battle to fight, to say the least. So Family Law Rule 26 that he keeps citing, it doesn't directly impact the right to challenge a dismissal. Other rules and statutes talk about that. I don't know what he's specifically citing in his appellate brief because I haven't read it. But let's just talk about this. A litigant who brings a paternity suit does not have an absolute right to dismiss the suit on the grounds that she is no longer pregnant. If the respondent challenges the dismissal on the basis of alleged fraudulent representation of pregnancy, the court can grant relief to the respondent, namely Clayton Eckert, over the petitioner's right to dismiss the suit if there are valid grounds for that relief. Namely, the judge believes that there was a fraud or a bad faith representation. So in the case of, for example, McKillen versus Hufford, this is 249 Arizona 69. The court emphasized in that case that a party who has knowingly and intentionally perpetrated a fraud on another party and the court cannot be entitled to relief under the rule in that same case. The principle suggests that if the respondent can prove, as the judge ruled that Eckert has, that the petitioner fraudulently represented being pregnant, the court may deny the petitioner's motion to dismiss the suit, which she did. So regarding Laura Owens' arguments about lack of subject matter jurisdiction, which he claimed that this was supposed to be like, he made this claim in a motion to dismiss the case. This is pre-trial. He made a motion that this is basically a defamation suit. He has every right to bring this in civil court under a defamation lawsuit. This is an improper venue to do this in family court. But he's wrong for all the reasons that we've outlined, because the court, this doesn't have to rely on defamation. This is relying on bad behavior and punishing bad faith representations to the court for improper purposes, completely separate things. And it is 100% the proper venue to do that in family court, because you could not have the same opportunities in a civil court that you would in a family case. Oftentimes, family law cases are greatly expedited. If you bring this as a civil case, this is like an 18 to 24 month litigation. You get it done in family court in like 6 months. And they did, by the way. They brought the motion in December. It was tried in June. Done. Right? So, anyway, there's this case, Dube versus Likens, 216 Arizona 406. It indicates that a defamation claim can be dismissed if it fails to state a claim upon which relief could be granted. However, this does not directly address the issue of dismissing a paternity suit based on fraudulent representation. So it doesn't fit. So as for the failure to follow Rule 26 requirements and respondents' alleged unreasonable litigation conduct, the case of Ash versus Arnold, that's 115 Arizona 462, highlights that the court has discretion to protect a party from annoyance, embarrassment, oppression, or undue burden, or expense under Rule 26C, right? So in that case, this suggests that the court can consider the conduct of both parties in deciding whether to grant relief to the respondent, and the judge did, and they denied Laura Owens' request to just dismiss everything. Nope, we're going to talk about this bad faith stuff. I want to hear more about that. That's what the judge said, and they had a whole trial over it. And that's how that went. So the court can grant relief to a respondent over a petitioner's right to dismiss a paternity suit if they can demonstrate that the petitioner fraudulently represented being pregnant. And the court will also consider the petitioner's arguments about the lack of subject matter jurisdiction, failure to follow Rule 26 requirements, and the respondent's litigation conduct in making its decision. According to the cases that I just cited, McKeon versus Hufford, Dube versus Likens, Ash versus Arnold. In short, I disagree with Gingras' premise on why he thinks he's going to prevail on appeal.
I agree because if not anything, while his argument does have a standing, I do believe that it is still on the discretion of the court. And the appellate court is going to look at all the evidence that was provided during trial and why the judge made the decision that she did based on the evidence, based on testimonies. And one of the issues that he definitely needs to prove is that appellate court, the trial court, made an error, and he needs to prove in appeal that there is an error of law.
Well, granted, on Gingras', he is claiming an error of law. I just don't think that he's correct.
But he's saying that an error of law is, okay, she's dismissing it, so therefore he does not have any claim to sanctions.
Yeah.
But there are also other rules that you just said,
Right.
and there are case laws
Right.
that also state that the judge does have the discretion
Right.
to take into consideration both the acts of both parties, the evidence, and when the law is not clear or there are conflicting laws, then as we know, the case law comes into picture. The case law takes precedence over conflicting laws.
Yeah.
That is why we use case laws as precedents. Otherwise, we just use the statutes and it will be way easier for us.
By the way, exit sign posted a comment. So in short, LOL, I think I said in short and proceeded to talk for like 45 minutes about the case law. I'm sorry. Look, I did the research. I had to get it out. I'm done now. I promise. I'm just saying that based on what I heard on Gingras' video, those are my questions. How is he going to resolve that in an appellate argument? That he's going to be before a panel of 3 appellate judges. They're going to ask him, okay, what about these 3 cases? In a way, I'm kind of helping him prepare for his oral arguments because they're going to ask those direct questions. What about the court's inherent discretion to punish bad behavior? Absent any law, Rule 26, Rule 46, or federal rule that doesn't apply here that you think exists, preventing it from happening, what about the court's right to proceed on its own motion to sanction parties that it believes is behaving badly? It's a problem. And so I don't think that is the strongest appellate argument that he has, honestly. I know that he's hinging it on his case. He's described it to me as a passion project of his because he wants to preserve a litigant's right to bring claims without being burned to the ground when they want to dismiss it, when they find out that it's just not going to work out. Either because they didn't know and they found out after the fact that it wasn't going to work out, or they always knew and they've figured out that, well, the jig is up, they got us. Let's just dismiss it, get the hell out of Dodge. That's essentially, to me, what's happening. So, there's that. Stephanie B says, her BS was so egregious, I think the court would side with Clayton if up to their... Well, the court did side with Clayton. Unequivocally sided with Clayton. The only thing that they didn't do was dismiss his OOP, Order of Protection for Fraud purposes, because the issue was moot. And there was other reasons for it. I think it was because it had nothing. I forget why. But there was a legal reason and a mootness issue about why that was rejected. But every other request that he had was granted. And so, Stir Crazy asks, Omar, does she know about the test? Little to no fetal DNA. Does she know about showing up in court with a fake baby bump and vanishing twin story? Stir Crazy? No, she doesn't. She literally knows everything you've heard me talk to Priyanka about is what she knows. She knows nothing about this case. And she was supposed to come on me with Family Law After Dark, and then I started talking about this case, and she'd give me weird looks. I was like, do you got something to say? And she's like, yes, I do. And so now she's on the show, and here it is. It's her first time on this podcast, and so there's a little bit of nerves there, but I think she's good now. So that is the take. Look, I came on here to defend my friend Lauren and Dave from the bullying and the threats that are going on. I think it's unbecoming of David Gingras to exercise his powers for bad and to threaten and to bully people like that. I will come to the aid of my friends and have their backs no matter what, whenever I see that happening. And I can tell you unequivocally that his claims that he's filing $150,000 lawsuits on the strength of what he described is not going anywhere. It's just not. It ain't. Look, I don't practice in Arizona, but I'm a bad motherfucker when it comes to legal research. And I didn't mean to curse. I'm sorry. I'm just saying he's wrong when it comes to that regard. Appreciate you. Hey, Dave, I love you, man. You're a good dude, man. You don't deserve all of the stuff that's been going on. So in short, I'm just going to conclude like this. To anybody out there in the universe that is fearful of a David Gingras lawsuit as it pertains to defamation for using his video that he published a couple days ago or a day ago, whenever it was, don't be. If it was in Laura Knight's situation, it is 100% unequivocal that you put your own stamp on that video and turn it in completely your own thing. There's not a chance that anybody's going to make any legal argument to the contrary. That lawsuit is an MSJ waiting to happen. Don't sweat it. To the merits of what Gingras previewed and I haven't read his appellate brief, and he hasn't filed it yet, but I have given him I've given him some idea of how his arguments are going to be attacked. So in a way, I'm kind of helping him out by making this video. I wasn't going to. I really just wanted to defend my friends. But those are the inherent arguments. If those are the arguments that he has on appeal, they're going to fail if that's all it is. So who knows, man? That's what we got. That's what we got. That's all I really got to say about Gingras, man. That's look, I'm trying to very much act as a mediator between everybody. I'm not trying to fight with anybody. I don't got any beef with Gingras. He hasn't threatened me, but he's threatened my friends. I'm going to come to their aid no matter what. I've talked to him personally. I don't got any personal hate for David Gingras. I think that if I were to meet him in Arizona, I had no idea he was an attorney. He didn't know I was an attorney. We'd probably be friends. Not like best of friends. I'm not best friends with most people. I'm just saying, I'm a very private person. I'm a very solitary guy. I'm just saying that I think he'd probably cheer for the Dodgers. I don't know if he's a Dodgers fan. Like the World Series, Game 7, Game 5, and cheers to the Dodgers World Champ. I'm just saying, I don't think that we would believe we were bad people if we were to meet in other circumstances. I don't believe that he's inherently a bad person. I think that he has some character flaws, but I think that he acknowledges them and he recognizes them and he can't help it. He genuinely cannot help being a dick. He can't help his nature to troll. I get being a troll. I troll my daughters all the time. All the time. It's the nature. I don't know. But the way that he interacts with people is problematic. There's people that would be willing to give him. I honestly was hopeful that these videos that he was putting out was going to be a bridge to maybe find some common ground between people that have been interested in this case and people that have been critical of his strategies and the way that he's been critical of others that supported Clayton Echard, and just everybody could kind of find common ground and move on. It's just not been the case. I'm disappointed in that regard. So I'm casting no aspersions at Gingras. I'm just saying that he's wrong in the way that he's threatening these other people, and he doesn't have a legal basis to do it, in my opinion. And I've laid out those reasons, and I've brought the receipts with case law and other things. And so that's all I got to say about that. To that regard, folks, I think that I'm going to wrap up this video with that. We've been going for an hour 25. It's like 25 minutes longer than I wanted to talk about it, but here we are. Do you have any parting words for all of your new fans?
I enjoyed here. I was a little bit nervous in the beginning, but I think now I'm doing fine.
No,
so.
you're still a little bit nervous. I think
Yes.
you're like halfway through that double. What did I give you? What?
You gave me the other one from
Woodford.
Jameson.
Woodford and Diet Coke,
yes.
right? Yeah.
But it has no Diet Coke though.
Dominic likes that too.
It is with me.
All right, folks. Hey, we're going to do Family Law After Dark in about 5 minutes. So if you haven't already, hey, Dominic, if you don't mind, drop the link to Family Law After Dark so people can make their way over there. I will see you guys over there. I got 5 hypotheticals to talk to you about. Hopefully, I'm going to be joined by Bruce and maybe Schnitzel and maybe Bruce, the IT guy. Brad, Jesus Christ. Brad, the IT guy. Jocelyn's going to drop in on here. We're going to have call-ins if you wanted to participate. We're going to get lubricated and have a lot of fun with alcohol. Alcohol. All right, folks. We will see you all over there. If you don't want to catch us over there, that's cool. Have a good weekend. Be safe out there. And we will see you next week. Bye-bye.